Good morning, everyone. My name is Josh Sello. Thank you so much for joining us today for our annual Legacy Society program. Normally we do this in person, but we're so happy to have you over the web today. Today we'll be talking about estate planning strategies in the time of COVID-19. And we're so grateful to have Janis A. Carney and her team from the law offices of Janis A. Carney here today to present on that topic and to answer your questions. Before we jump in, just one bit of housekeeping. All of our attendees today are on mute, but if you do have questions, we absolutely want to hear them. Please use the Q&A function at the bottom of your screen, and Janis will answer those questions during her presentation. With that, I'm going to go ahead and get started. Now, I know we have some folks today who might not know much about West Valley Community Services. So before we jump in, I just want to share some information about what we do and what we're seeing here since the start of the COVID-19 pandemic. So I'm going to start off by sharing our agency video with you, which will tell you a bit more about West Valley Community Services.
I was homeless for about, I want to say a year or two, and it felt like nothing was going to happen. I slept on a public bus for a little while. You never think you're going to end up in that situation, but when it happens, it's kind of like, you're just in a state of panic. You don't really know what to do.
Well, I thought teaching 34 years and retiring after a teaching career that I wouldn't have to reach out like this.
My fourth child was a special needs child. People don't understand how hard it is to work when you have a special needs kid. We lost our home. We went through bankruptcy, foreclosure, and divorce sort of all at the same time. And that was a real low point. It was really, really hard.
I really needed their help that month I came in. I had a 30-day notice and had to move out if I didn't have any help.
West Valley Community Services is a human service nonprofit that's been serving the West Valley communities of Cupertino, Saratoga, Los Gatos, Montessorino, and West San Jose for 45 years. We provide for the needs of low-income and homeless individuals and families, and our mission is to unite the community to fight hunger and homelessness.
Nothing worked. I tried everything I could do, and then I just thank God I found out about West Valley Community Services. I am so grateful for them. I really am. Everything, the apartment, they even provided us our beds, the sheets for our beds, bed protectors, all that stuff. Right when we moved in, they told me about a program for rental assistance. I was on the verge of eviction a couple of times, but they kept me here, for some reason, and I appreciate them for that dearly.
We were struggling at the end of each month, and West Valley Community Services has really helped us with our food budget.
It may be hard to believe, but each year, West Valley Community Services distributes over 800,000 pounds of food to hungry people in our community. Our food pantry is pretty unique in a couple of ways. One, it's completely run by volunteers who are here every day sorting food, stocking food, and picking it up from local grocery stores. Our food pantry is also unique because it's a shopping pantry. Clients come in and they choose the food their family will eat based upon our available inventory. It's very much in line with our values, focusing on the dignity of each individual client, making sure they have what they need to make sure their family is healthy.
Driving down 17 and back would be about 3 hours, and it's just fabulous that the van comes up to our local church and drops off the food. The price of living and the cost of books and tuition leaves very little money for students to get food. West Valley Community Services offers a mobile pantry and goes out to the colleges in the area and gives students the opportunity to take home a box of food for their family and for themselves to prepare a good, healthy meal.
All the programs at West Valley were just terrific in terms of the back to school program for the clothes for the kids, and the backpacks with school supplies were so helpful, and then the Christmas program was, I mean, we wouldn't have a Christmas without the program that West Valley does here. All of those things have just been like lifelines for us.
This work is not possible without the community coming together to help those most in need. Each year, over 600 volunteers make the work here at West Valley Community Services possible. Some volunteers are here every single week, helping at our front desk, in our food pantry, or in our back office, making sure that we are able to serve the needs of our community's most vulnerable individuals. In the last 6 years, the median cost of rent has gone up by over 20%. For folks who are living on the margins or who are earning minimum wage, annual increases like that have made it impossible to keep up. Families that were just able to get by in the past now are struggling to cover their basic necessities, their food, their rent, their transportation, their childcare. That's why we exist. We exist to keep families like those in their homes and make sure that their families are fed, and so that they can have a future that's brighter than their present.
I don't know if we would have made it without West Valley Community Services or not. I mean, the groceries have just been immensely helpful, and all the programs have been so helpful.
It's good to know that there are people that care still in this world. And when I mean people, I mean West Valley Community Services.
So now you know a little bit about our mission, uniting the community to fight hunger and homelessness, and the work that we do to provide food support and resources to low-income and homeless individuals and families. We do that through a variety of different programs, our 2 food pantries, one here in Cupertino, and our mobile food pantry, emergency rental assistance, financial coaching, education, referrals, and special programs. Since the onset of the COVID-19 pandemic, however, we've seen an unprecedented increase in demand. And for those of you who'd like more information, you can visit our YouTube page and see a webinar we did 2 weeks ago that detailed all the changes we've made in our office to serve the growing number of people who needed help since the beginning of March. Here you can see we've had a 300% increase in need for rental assistance, 117% increase in the number of clients visiting our mobile food pantry, and 505 new clients since March. And just to give you some perspective, typically in a year, 12 months, we see about 800 new clients. So we've seen such a huge increase in people coming to us for the very first time. And in order to meet the demand and serve the needs of seniors who really shouldn't be leaving their homes, we've started a new program offering food delivery to seniors in their homes. We've been able to do that by working with our partners, providing rental assistance to keep people housed, expanding our pantry, and now working with a capital campaign to even build greater capacity in our pantry and build a new mobile food pantry to serve the growing number of people who need help. And of course, right now we're doing all that by maintaining social distancing and safety protocols to keep all of our staff and volunteers and clients safe. With that, I want to pivot to why we're all here today, and that's for our presentation on estate planning in the times of COVID-19. And it's presented by our Legacy Society. The West Valley Community Services Legacy Society brings together people who want to make sure that West Valley Community Services can continue to do our work for many, many years into the future. This is typically made by making a gift to us in their estate plan. And there are all sorts of benefits to being part of West Valley Community Services Legacy Society. You can see them here on the screen, and you can also find out more by visiting us online at wvcommunityservices.org. With that, I have the pleasure of introducing our speaker today, and that is Janis A. Carney and the team from the law offices of Janis A. Carney. So I'm going to just tell you a little bit about Janis. Janis is a California attorney whose independent law practice in Saratoga specializes in estate planning, trust, and probate law. Janis has served on the board of trustees of the Silicon Valley Bar Association for over 10 years, including 1 year as its president. She has served as the SVBA's Estate and Trust Committee's judicial liaison to the probate court in Santa Clara County and has been a frequent speaker over the years at programs on various elder law matters. Janis, we are so grateful for you taking the time to spend with us today. Thank you so much. I'm going to turn it right over to you.
Thank you so much, Josh. That was a beautiful introduction. And it was a beautiful video that you had about West Valley Services. Your organization is so important to our community, and I really am so grateful that you exist and honored that you have asked me to speak today. Of course, I know that you love to have donations all along the way. I am going to be talking about estate planning today and the opportunity to leave legacies through an estate plan will be woven throughout my presentation. So with that, I'm going to screen share here so I can get my presentation out to all of you. Let's see. And okay, get it there. All right, I think that should have you seen it now. Our topic today is estate planning strategies in the time of COVID-19. I always like to talk a little bit about why I name a program what I do. There are lots of different strategies in estate planning, and every strategy is unique to the situation of the person who is the plan is for, and the family that is being considered. In the times of COVID-19, there are some differences in it, a little bit of differences anyway, and we're going to talk about that. But basically, estate planning is the same now as it ever is. So let's get started. We always have to start with a disclosure. Everyone gets these. I want you to make sure that you understand this is an educational presentation and it's not legal advice. The concepts presented here contain exhibits and explanations and caveats that may not apply to you. Please seek legal advice from your own attorney or another attorney of your choosing who specializes in estate planning or elder law regarding your circumstances. Okay, so now why are we here? So the reality of COVID-19 has forced us to question, are we really ready for if something would happen to us? People come to me all the time at the point of time when they have developed an illness or they feel that they are growing older and that they need to update their estate plan or create an estate plan from the very beginning. I am a regular estate planning attorney. I can do estate planning for everyone, but as an elder law attorney, a lot of people come to me as they are aging because I can provide, in addition to estate planning for what's going to happen when you die, but also help for what happens when you don't die and you age. So as I said, in the period of COVID-19, we are seeing people think about these things and feel like they need to get ready now just in case something happens. So today we're going to be discussing what if something were to happen to me? Am I prepared with the right legal documents? Will my estate plan protect me and my family? What's needed if I pass away and lose capacity? Does my trusted someone, I'm going to be explaining that term, why I use that term, do they have authority to handle my affairs? And what if my family needs to access funds, maybe through my IRA and life insurance to pay expenses and planning in a pandemic? What legal documents are needed? Do I need an estate plan? Okay, I want to explain what an estate plan is. An estate plan to me is like what you get from an architect when you're going to build a house. It's the fundamental plans. It's figuring out how all of the pieces are going to work together. Exactly, where's the bathroom and where's the kitchen and the bedrooms and all of those pieces All of those pieces in an estate plan are going to be created by virtue of legal documents, which are the tools of the estate plan. And I was actually doing some research on hammers the other day, and I didn't realize that there are almost 100 different kinds of hammers, and that every hammer, the hammers have developed because of the different aspects that they need, the different jobs that they need to do. And that's very analogous to the legal documents in an estate plan. While we might do living trusts, every estate, or a lot of estate plans, are going to have a living trust in it. There are probably 100 or 1,000 different versions of a living trust, and how they work is going to depend on the actual situation. So everything is different. The legal tools the legal documents are the tools of the estate plan. And the architect here is the attorney who now knows how those tools work together and what they're supposed to do and how to draft correctly in there. The right legal documents will allow you to provide for a trusted individual. That's your trusted someone. We're going to talk a little bit more about that. And the documents are going to give that person authority to manage your financial affairs and make decisions when you cannot, and then also after you pass on. This disposition of your estate is going to be important in some of these legal documents. It needs to be in a coordinated plan to ensure that your loved ones not only get your money but at your death, but it's protected for them if necessary. So let's talk a little bit about the specific legal documents. The documents that dispose of your assets at death are these 5 that are on the screen. There's trusts. Now, the trust can have 100 different kinds of trusts, but there's trusts, there's wills, there's variations in wills. Beneficiary designations are the forms you fill out for like your life insurance and your retirement plan. And those documents control those specific assets. They are not going to be affected by anything you put in your will or your trust unless you have named your estate or your trust as the beneficiary on those forms. And sometimes an attorney will have you do that. But the beneficiary designation forms do dispose of your assets, of that particular asset, according to what you have on there. And that needs to be updated from time to time when you change your trust or your will, or your people die or things happen in your life. You want to update those designations. Survivorship titling, most people understand that you can have a joint account with your husband or wife or mother or father or something that is a joint account where either one can sign. You can have joint accounts or joint titling on deeds to real estate and other kinds of investments. If those titling carry with it a right of survivorship, that means if one of the persons on the deed or on the account dies, does it automatically belong to the other one? That's what I'm talking about, survivorship titling. If the account or the deed is set up in such a way that it carries survivorship with it, that's who's going to get that account or that property at death. And it's according to the titling. It's not, again, going to be affected by your will or your trust or anything else. It's going to go according to the titling. There's a 5th one on here. It's a transfer on death accounts and deeds. Transfer on death accounts is where you might go to the brokerage house and say, I want to set up an account so that on my death, it's going to go to my grandchildren. And they could put on there that it's to transfer on death. It's your account until you die, but at your death, it passes to your designated individuals. You can also do that on real estate now through a deed. That's only happened in the last several years. I don't really favor these documents or these deeds, except in the very, very, very simplest of cases. And even then, I don't recommend it for real estate for very complicated reasons. But sometimes this is what people set up. If it is set up to go according to a transfer on death account or titling on a deed, that's who's going to get it upon passing, your passing. Documents for decision-making while you're living and to handle your financial affairs while you're living are a separate set of documents, except we also have the trusts involved here. I'll get to them in a minute. The most important documents, I believe, are the power of attorney over property and financial affairs and the advanced health care directive. In California, these have to be two separate documents. You can't put a power of attorney over healthcare in with the financial and vice versa. So the powers of attorney over property and financial affairs needs to name your trusted someone who can handle your financial affairs if you become incapacitated. It's important for everyone to understand that this document expires when you die. It is not a document that's going to be available to manage your affairs after you pass on. So, but it does need to be it is a powerful and important document for if you lose capacity, or in this time of pandemic, if you ended up in the hospital and isolated and on a ventilator, while you might be competent, you are not able to handle your affairs. So we'll say you're incapacitated. So the power of attorney needs to be there to have somebody handle those affairs for you. The powers of attorney can be very limited and very simple in their writing, or they can be very detailed and very complex. I tend to go for the complex and the detailed because my clientele a lot are elders, and we might end up using this power of attorney for a very long time as someone ends up suffering from dementia. And it might not be just something that you use for 6 months or some other short period of time. It might be something we use for a very, very long time. And you need to know that a lot of the documents that you might see out there are a general power of attorney, and you might have seen it with the boxes, and you check the bottom one, it says all of the above. All of the above are just the general powers. They don't include the specialized powers that might be needed for gifting or control over trusts and various other things that especially we want to include as people age. So I encourage you to make sure you go to an attorney to get a very thorough one created if those are your concerns. Advanced healthcare directives are a document that was created by California law in the year 2000 under the Advanced Care Act. It at its core needs to be and includes a power of attorney over healthcare. And as you will see on the slide, I also have personal care. So you can have this power of attorney over healthcare. You can also have a power of attorney over personal care. Why is that important to put in personal care? Healthcare are the kinds of things that your health insurance covers, medical treatments and hospitalizations and maybe rehab, but it doesn't cover personal care. Who's going to be hired to care for you in your home? What nursing home are you going to be in? Those kinds of things are personal care. And if you don't have that as part of your advanced directive, and there's a dispute in your family, that can become very, very problematic. Power over disposition of remains is one aspect of these documents that does survive your passing. It does control where you're going to be buried or cremated, whether you're going to be buried or cremated, and where you're going to be potentially buried. You can instruct in what your wishes are in this, or you can just give the authority to the person, or you can say that this person that you've named under your advance directive doesn't have authority over these things. So it's a very adaptable document to what your wishes are. Another very, very important, even if you don't have the personal care, the disposition of remains, you ought to have a statement in this document about end-of-life decision-making, end-of-life wishes. It generally is going to have some kind of specific criteria. Maybe if you're in a coma or persistent vegetative state, or you're terminally ill and the use of life support will only sustain you for a short while, or if you the burdens of your treatment are going to outweigh the benefits, that might be your wish to not have life support at that point. But it can be much more complete with instructions about quality of life. You can have a statement that under these kinds of circumstances, I would not or would want certain things. You can say how important various things are to you, and this can be as elaborate or simple as you like. But those are the kinds of things that are in advance directives. I encourage everyone always to have an advance directive. If you get one from a medical provider like Kaiser or the California Hospital Association or Sutter Health, many different ones have it. They're generally only going to be concerned about the power over healthcare. They may have your end-of-life wishes in there too, because they are focused on making sure that there's someone to make healthcare decisions. If they have the other parts of them, that's wonderful. But if they don't have it, then you should seek out a form from an attorney or other person that you can get the other provisions, because they are really important. HIPAA stands for Health Insurance Portability and Accountability Act. HIPAA is the Medical Privacy Act, the federal act. There is a California version of it as well. That usually there's a provision for waiving HIPAA in most powers of attorney over property and most advanced healthcare directives. And that's good, because they need to be able to talk to your physicians to make sure that you've lost capacity before the document generally takes over. But you can also have a HIPAA waiver that stands alone. And I usually do one because I want to make sure that attorneys and others who might need to find out about your level of capacity have the ability to get that information from your physicians. If you are in a ICU, for instance, and you would want other family members, more distant family members who are not named as your agents under the advance directive, to get information about you, maybe you can put those in your HIPAA waiver as well. The HIPAA waiver does not give somebody authority to make any decisions about you. It's just a waiver so that physicians and other health providers can provide information. Trusts are important while you're living as well, because this is a place where you can designate someone to take over the financial affairs of the trust, to manage the assets that you put in the trust as a potential successor trustee. And then you would not have to use the powers of attorney with those documents. However, there are things that a trust cannot do, so you always want a power of attorney to go with it. The WHO, fiduciary rules. This fiduciary is something you may or may never have heard of. Fiduciary is a concept in law that says that a person who is your fiduciary holds the highest duty of loyalty and to you, and must act in your best interest and not in their interests at all. Typical fiduciary roles could be the trustee of a trust that you've created, or is for your benefit, an executor of a will, an attorney in fact under a power of attorney, an agent for healthcare, conservator, or guardian of minor children. These are all fiduciary roles. And you can imagine that the level of trust that you put in that person. And because you put in such trust into that, a breach of fiduciary duties is a very serious offense in the law. So that person needs to be understanding that they are acting not in their own best interest or for their own self-interest, but for the good of the persons for whom they are the fiduciary. Who should be named your fiduciary under these documents? You might name a family member. Most people do, but some families don't really have, or some individuals don't really have family members that are appropriate. You might name a trusted friend. And if you don't have either, you might be naming a professional, especially if you have significant assets. Professionals are trained to do the work of a fiduciary. You might have a professional who is an attorney or a CPA, but in California, we also have a licensed professional who can serve in this role, and they would be called a California licensed professional fiduciary. A lot of banks and trust departments also will serve as a professional fiduciary. So you can go in that direction if that works best for you. Choosing carefully. I think there's three A's that you need to think about in choosing who to name as your fiduciary. You want someone with the ability to do the work. If it's financial, they need to have be able to handle finances. They need to be able to handle their own finances. It would not be so good to name someone who's been in bankruptcy or just doesn't have the ability to manage money. But in addition to that, if it's someone over your healthcare, you might have someone who is a nurse or has the ability to talk to physicians and others and to understand the medical field. It also ought to be someone who has the innate ability to make health decisions and is not going to be unable to make those decisions for you. In addition to ability, you need to think about availability. Is this person, even though they might be a CFO of a big corporation, are they going to be available? They may have such positions that they don't have the time, or they won't have the time. They might be traveling all over the world. Well, in normal times, they might be traveling all over the world for their work. But availability is equally important. If it's someone who's going to be over your health care, they ought to live somewhere nearby, maybe instead of in Europe. Now, if they happen to live in another state, and with today's technology, that's not something that can't be overcome. But being far, far away would be a difficult thing for someone to serve in that role. Appropriate. By this I mean someone who is able to be fair, impartial, and to do what you want them to do, not just act on their own behalf. They need to be able to understand and appreciate that they have this fiduciary role and that they must act fairly for everyone and not in their own best interests. In times of COVID, the next item, primary versus successor, is I think more important than ever. You might come up with your first person and you might have that very best person, but then who's the second best person and the third best persons? It's really important to have successors now, because we just don't know if someone that we have named is going to get sick and be unable to continue in this role. Or that they're going to be where you are. If they are a physician and they are an emergency room physician, they may not be able to make decisions for you, be there if something happens for you. So you want to make sure that you have successors named. They may not be as good a choice as your primary, but let's get some successors named. I want to explain the difference between alternates and successors. In your advanced health directive, generally we are naming alternates. You've named your primary one, the one that you want to make decisions if they're available. But if they're not available, those documents generally say then the next one's in line in some kind of order. And but if the first one becomes available again, then they're back into the seat. A successor is more like the presidency of our United States. There's one at a time. And when that one's term is over, they don't get to come back. So if the primary resigns or becomes unable to serve, then the successor turn takes over. It could be that we write it so that if a primary is temporarily unavailable or incapacitated, that the successor serves during that time. So that can be written into documents, but generally it's one at a time and it doesn't go back and forth very easily. Co-agents, lots of people want to name co-agents. I think co-agents will work if the agents can work together. Generally, we don't name co-agents under a healthcare directive because it's hard for people to make these decisions, and it needs to be somebody who's going to make the final decisions. You might say that all of the agents that you've named should consult on any end-of-life decision, but that you've only named one. On the powers of attorney, co-agents oftentimes have independent powers, as well as in a trust. They might have independent powers, but they will have to work together on the big decisions, like a sale of property. Discussions with families are very important when making decisions about these things, because if we have dissension in the family, it can cause lots of problems. Even if the ultimate decision is yours and others don't agree with you, at least they've had their opportunity to say what they think. And that's going to go a long ways towards resolving conflict. Providing for intended beneficiaries, you need to figure out, okay, who's going to be your beneficiaries? We've talked about fiduciaries, now we're talking about beneficiaries. Who's going to get your assets after you're gone? Is it going to be family? In the family, I want you not to forget parents. If you've been caring for parents, then you die first, then you might be wanting to provide for parents and other elders. Friends, charities, of course, West Valley Community Services and other charities, we all need to keep that in mind to be good stewards of our world in our community. Pets might be someone that you want to leave something to. You can't really leave it to a pet, but you need to provide for your pets. These are all the various kinds of things. As I said earlier, life insurance and retirement accounts generally have beneficiary designations, but those are part of your estate plan. So we need to coordinate that with everything else and make sure that the who of that, it coordinates with the who under your will and your trust. Sometimes the will or trust is named as not the will, but the trust is named as the beneficiary under these things so that the funds will flow into the trust for distribution. How to distribute? Do we distribute outright? Do we distribute in trust? And I'm going to be talking about situations where you probably want to leave it in trust in just a minute. But, if there's no reason not to distribute outright, that's the simplest thing to do. Specific requests are specific dollar amounts. You might leave $10,000 to West Valley Community Services or to each of your grandchildren, something like that. I implore you not to leave too small of a bequest because there's a lot of expense in the administration on the back end. So there's other techniques that we can use to give something to someone if it's going to be small. The specific bequest can also include specific items. You want your beloved grandfather clock to go to a special person. You want tools to go to the oldest son, or jewelry to go to the granddaughters. Those are the kinds of things that people put in specific bequests. There are limits about what you can do on that. You need to see an attorney about that. Residue disposition is the things that you have not named a specific person on. Everything that you've left without a designation about it is going to be part of the residue. And you're going to have want to have a provision that says everything else goes to these people or these organizations, or these people and organizations. And you're going to be able to divide it into shares or into percentages. There's lots of different ways that we can set up a disposition scenario. The default provisions come in if you have documents and you haven't named somebody under one of the ways I've just talked about, and it's left over. If you don't have a default provision in your documents, the state of California has one for you. It's called intestacy, and it will go to your heirs as defined by law. If you want heirs to be your default, you can put it right into your trust. You could also say that your default is going to be a charity. I always tell anyone that in deciding on your default, it has to be something or someone that can be defined by law that is not going to die. Because anyone that could die, I'm going to put them on that plane with you when you die, and so now they're gone too, so then what? And so the default needs to be, generally it's your heir, it's the word heirs, or maybe you say it's your husband's heirs because you don't want it to go to your family, but it needs to be somebody's heirs or a charity, which could be, even if it's not in existence, can be, a new one can be found that's similar to it. So those are the default provisions. Thinking about your intended beneficiaries, this is where I want you to think about, should it be outright or should it be in trust for some of these people? And what are the terms? What if a beneficiary predeceases you? Your whole family goes down on that plane. Who gets it then? Does it go down the line of to the descendants of the persons you named, or should it go to the other persons you named, or should it go to somebody else? These are decisions to be thought of. What if a beneficiary has problems? There's a whole list of them here. Disabilities, addictions, spendthrift. That means somebody can't manage money. It goes through their hands like water. Are they in bad health? Are they in a bad marriage? Do they have debt, very large debt? If you give something to someone who has large debt, it's like giving it to their creditors. So that might not be what you want to do. Criminal convictions also often carry a victim's compensation fund that has to be paid into by the convicted person. And that can lag behind them even after they're not in prison anymore. So you might be needing to make special arrangements in your estate plan for persons who have any of these kinds of problems. Especially addictions come up quite a bit, and disabilities, like someone needs a special needs trust because they are developmentally disabled or they're mentally ill and they need to be on public benefits. Addictions, a lot of people are afraid if they give too much money to someone who has a drug addiction, they might just buy so many drugs that they literally kill themselves. because they have the funds to do that. So these are things, these are real world problems that a good estate plan can try to resolve. Do you have children that you want to treat equally, or are you going to treat them or provide for them according to need? This is always a big issue for clients who have children of different economic abilities. You might have someone who's the CFO of a great, or a CEO of a very successful company, and then you might have another child who is a teacher and is living very meagerly. So do you leave it equally to both of them, or do you leave more to one than the other? Those are all very personal decisions. Do you reward a child who's taken care of you for a long time by leaving them more? Sometimes people want to leave that person the house and leave just a token gift to the other children. But you would be surprised that the other children might think that that's totally not fair, and that the one who's taken care of you has unduly influenced you into doing that. So I really implore you to talk to the entire family about that and make sure everyone's on the same page and agrees what the appropriate disposition is. In saying that, estate planning is your personal decision and it's your personal business. And if you don't want to talk to anyone else about it, that's your decision to make. But I'm just talking about what's best for your family. What funds are best to allocate to charities? My favorite asset funds are your retirement accounts, because those are going to be income taxed to individuals who receive them, but charities don't pay income taxes. So leaving it to a charity means that they're going to get more of, or the money is going to go a lot further instead of taxes being withheld from it. Avoiding unintended beneficiaries, predators, creditors, heirs at law. Heirs at law might not, you might think, well, okay, I'll just let it go to my heirs, but you might be surprised who your heirs are. If you do not have children, your heir, and you have a spouse who died within the last 15 years, some of your assets might go to your predeceased spouse's family. So it's not just your next of kin, it might be your predeceased spouse's next of kin in some ways. That may not be what you want. Outlaws, in-laws. What I mean by that are your sons, daughters-in-law that are no longer married to your children. Or it might be that you leave it to your child outright and they're in a divorce situation, and so their soon-to-be ex-spouse is making a claim for some of those assets. Medi-Cal is a program to provide health coverage if you are financially needy. A lot of people in my practice get it for long-term care in a skilled nursing home. And Medi-Cal can make a recovery claim against anything that goes through a formal probate in California. So you need to make sure that the assets are passing by some way that isn't going to be just your will, because a will does go through probate. Predators and creditors, creditors pretty much you understand, but there are ways to limit the ability of creditors, either your creditors after you die or the creditors of your beneficiaries. The predators, lots of people talk to me or come to me and complain about someone who seems to be ingratiating their way into favor an aunt or a grandparent or someone's best wishes, and they're afraid that they're going to steal the estate. And that happens a lot. The best way to avoid predators is to have a wonderful relationship, a close relationship, and make sure that there is an ongoing estate plan from early on, not when that person starts losing capacity. IRS and Franchise Tax Board, those are tax collectors that are going to get a piece of the estate under certain circumstances, this is a much bigger conversation. So you just need to talk to an estate planning attorney to make sure that you've minimized any taxes that are going to be due on death. The county tax collector, I put that in there because of the Prop 13 advantage. If there's a property with a nice low assessed value that you want to pass on to the family, you need to talk to your attorney about making sure that that can pass with that property. Probate courts and attorneys, that was sort of a chuckle that I put in, because if you don't plan with trusts and other documents, you might end up in probate court, and that's going to get expensive, and you might think that they're an unintended beneficiary in your estate. So plan well to avoid all of these. Keys to planning for an intentional inheritance: you need to develop a plan to share, and in that you want to share knowledge. You want to communicate with family and have family communicate between them. You want to make a decision, have a plan for decision making. I believe that these are going to create an intentional inheritance scenario in your family. I believe you should be establishing establish and communicate your family values, your goals, and your aspirations. You're not just passing on your money and your other assets, but you're passing on who you are and your values to your family. You might be wanting to create a legacy, a charitable legacy as part of a family value. So these are things that you need to establish and communicate to family. Arming your children, grandchildren with the tools needed to succeed, especially if there's a family business. You want to make sure that they've been mentored and trained and they've been taught what they need to do in order to succeed. You want to transmit values, as I mentioned about before. You want to communicate, establish those values, communicate them, and transmit them a lot of times through philanthropy. Those of you in the Legacy Society here at the West Valley Community Services already have this as part of your value proposition. But these are things that you might think about, and you might be, you know the old adage, do what I said, do what I people are going to do what you do, not what you say. You might think you can do it the other way around, but they aren't going to do that. But I take it one step further. You want them to see what you do and to set examples. Envisioning family as a successful business is another way to structure your intentional inheritance. You build a structure for that, your wealth and how it's going to pass through, develop mentorships with your family. You might be saying, oh, Janis, I already have all these documents. Aren't I done? My answer is no. Very profound, very explicit no. Planning is not a once and done proposition. You need to review your documents periodically. And even if your documents don't need updating, it's important that you communicate these documents to your family who are going to be in charge of administering them. You might take them with you to the attorney so that they can ask some questions about what their role is going to be. Circumstances that might mean that you need to update your documents. Usually I say it's wealth, health, beneficiary needs, beneficiary existence. You might have people born into the family or die that you might need. Some things that you might not be aware of are changes in the law or changes in the standard of practice. The long-term care plan that I would create for someone 15 years ago is not the plan I would create today because of standards in the practice as well as some law changes. So seeing your attorney at least every 5 years is a good rule of thumb, even if nothing has changed, just to find out, are these documents still as fresh as they ought to be? You need to also, this is really important, at the very first signs of incapacity of your loved one potentially, you need to make sure that the documents are reviewed so that they can be updated one last time before incapacity becomes too grave that they can't be changed. We're going to be talking now in the last few slides about taxes, what about the pandemic, and what about my investments. We're going to talk about the two major tax acts that have been very recent. This is not a program on taxes of your estate plan, but I want to bring up a few things there. Let's talk a little bit about the pandemic and how it's affecting your estate planning and then your investments in the current situation. Ugh. Didn't mean to hit that. Okay, tax planning. The Secure Act, this is an act that was passed at right about Christmas time and became effective on January 1 of this year. It affects your retirement account. If you haven't heard about this, you need to know some pieces of this. There are many more pieces of it. These are just the major things that I think that we need to talk about a little bit today. You need to know that this act affects all kinds of retirement accounts, IRAs, Roth IRAs, 401ks, all of them. Your own, there's two different sections of it. One is the changes that are going to affect your own retirement account while you're living. Two major things there is one that you can continue to contribute to it from your earnings. That means if you're continuing to work and earn money as long as you live. So it's no longer limited to just 70 and a half. It can be for the rest of your life. But there is an important warning here. If you want to donate part of your required minimum distribution every year to charity directly, those contributions, those funds that are in the IRA cannot have been contributed to it after age 70 and a half. So if you could set up separate IRAs for this, but most people it would be better to just stop contributing if that's going to be what you want to do. And that is a wonderful thing with someone who has enough income that they don't need the income from their required minimum distribution to have it just peel off and go annually to charities. That's a great tax planning opportunity. Again, the charities get them tax-free. Whereas the individual, if they were receiving it themselves, are going to have to pay income taxes on them. So it's a win-win. Required minimum distributions now do not have to start being deducted or withdrawn from the account until you're age 72. Of course, if you already we're in that stage where you had to take them out. That means if you were 70 and a half before January 1 of this year, you can't turn them off. You have to continue. So it's only for those people who had not reached 70 and a half by January 1st, and you don't have to start taking out until you're 72. The other the major effect or change by the Secure Act is on inherited retirement accounts. That's your account after you die that's passing on to your beneficiaries. The general rule now is that the entire account balance must be withdrawn by the end of the 10th year after you die. And there are no required minimum distributions from the account during the time up to that. That means years 1 through 9. So the account can just sit there, continuing to grow tax-free inside of it, but at the end of year 10, it all has to have come out. It might be a better strategy to make sure to make distributions along the way to so that you don't have a huge tax in that last year. You might be able to minimize the tax by making distributions along the way, but that's something you need to talk to your tax expert about, your CPA about along the way. There are some exceptions to that general rule. The old rule used to be that you could stretch out distributions over the lifetime of the beneficiary. And that is still true. You have that lifetime stretch for distributions for certain categories of beneficiaries. Persons who are spouses of the participant can stretch out. They can also do a rollover. I want to make sure that I throw that in there. The rollover to a spouse is still available. It becomes their own account, and then they're back up at the first part of that, treating it as their own. But if they're treating it as an inherited account, they can do a stretch of the distributions with the annual required minimum distributions annually over their life expectancy. Others who are within 10 years of age of the participant, and I think of this as maybe siblings or that significant other that you've had a relation, your life partner that you've been with for 25 or 50 years, but you, for whatever reasons, decided never to marry. Those persons can, and if they are within 10 years of your age, they can also do the stretch. Disabled children, that's going to be defined a little differently than for other public benefits, but disabled children can also do a stretch, and minor children. Now, minor children have to be minors. Once they are no longer a minor, then the 10 years start. And what is a minor child is currently being defined by state laws. Some states, like California, it's a person who's under 18. In other states, it might be 21. I sort of think that the IRS is going to promulgate regulations that might create a uniform age, maybe 21 or maybe 26, like they have on some other kinds of things. Tax planning also includes the CARES Act. Most people know that's the act that was recently passed as an economic stimulus or relief, depending on who you listen to, package to help small businesses and help individuals, help corporations with the financial impact of the pandemic. The retirement accounts, there is a provision of that affects retirement accounts. And those, some of those rules are that there is no required minimum distribution required for this year, for 2020. If you do take out money this year, you can defer those, the tax on it for up to 3 years, whether or not it was required minimum distribution money or it was not required. It was, you were pre the age where you had to take required minimum distributions. If you take withdrawals from your account, you can defer the taxes up to 3 years. There's also a suspension of the 10% early withdrawal penalty. So if you're under 59, you can take out funds. You still are going to have to pay the taxes on it. Again, it's going to be deferred up to 3 years, but you can take it out without that 10% penalty. I forgot to put one other on here, and that is that if you take funds out and you can replace the funds within the 3 years, then there's going to be no tax on that transaction. There's probably more financial aid to come, so, and this isn't everything, this is just a few things that I think were important to bring up here. Okay, living through the pandemic. This is what if this happens to you? Some thoughts that I have about that is that you need to make sure your affairs in order. We do, if you would like to have a handout that we can provide that is recommendations about how to get your ducks in a row. What are the kinds of documents that you should find and make sure that everything is put together? Please just reach out and we'll be glad to provide that to you. Do you have a plan already? If you don't, you need to come up with one. And who will this affect? And when I'm thinking about this, I'm thinking about if you become sick, who's that going to affect? And it might not be just, don't think in terms of it as just the others who might get sick that might be cared for. If you're a caregiver for somebody else, how is that going to affect those people? Maybe you have young children. Maybe you're caring for an elder. You need to make sure that you have made a plan and communicated that plan with somebody else about who's going to step into your role as caregiver. That caregiver, if you've got a family who have dementia that you're the caregiver for, you need to make sure, especially that the authorities, that something in your purse or somewhere has that information that you're the caregiver in case something happens to you. Someone can get in there to take care of those, and pets. If you get sick and you have a pet in your home, somebody needs to come in and make sure that that pet is taken care of. What can I do to help? Of course, we all know about social distancing, masks and gloves. That's talked about a lot. So we need to do that for each other to help make sure that this pandemic can go away as fast as possible. We need to check on neighbors and elders, especially during this time. Yes, you need to keep your social distancing, but it really is important to reach out and make sure that people feel that there's still people out there that are caring about them and that they're not totally isolated and alone. I believe we need to support and appreciate those in the front line of all, the grocery store and the hospitals, in whatever way we can, either through contributions, buying food, or just the applause that is so touching. And donations to charity. Donations to charities, especially those like West Valley, who are providing food and rent assistance and other kinds of assistance to those in need right now, are in great need of additional funding. So if you have the wherewithal to do that, I encourage donations now, but also you don't forget that you can put them into your estate plan for later if something happens to you. What about the economy? What has happened to your investments, getting cash for expenses? I'm not your financial advisor. The very last item there, I implore you to talk to your financial advisor and your CPA about all of these things. But here are some things that I think that you need to think about. If the declining market, this is only going to be affecting you individually if you were invested in it. If you weren't, then you have cash to invest now, maybe this is a good time to get into the market. If you are invested in it, can you wait for the recovery? Because, the financial people will tell us that it will recover. It's just how long will it take? So if you can avoid taking money out of your investment accounts now, that according to a lot of the financial advisors is the appropriate thing to do. Again, I'm not telling you what to do. I'm telling you to talk to your advisor. Businesses, of course, we don't know, we know that there's a lot of talk about businesses that are going to go out of business. If you have a business, are you hanging in there? Are you thriving? Or are you going to be adapting? These are all the kinds of things about the economy that people are thinking about. Real estate sales, if you are we're in the position of selling real estate currently, our experience with some clients who've been selling property now is that the market hasn't changed a lot currently, maybe a little bit. The sales might be slower, but there's less property on the market, so it's sort of hanging in there. Forecast for next year, I've heard all kinds of things. Talk to your real estate professional. If you have a donor advised fund, that might be a way to give to charity right now. So remember our host, but also think about using those funds instead of using the funds that you might have invested that you don't want to take out of the market right now. You might take money out of your IRA. Again, I talked about the fact that you can defer the taxes for 3 years. You might be able to replace it later. So that might be a place to take it out. You will pay tax on it if at the end of 3 years, if you have taken money out of your IRA. So that's probably not a great place to take it out unless you need to. You might consider, as a planning device, rolling your traditional IRA into a Roth IRA right now. The Roth IRA, you would not pay the tax on the withdrawal from your traditional IRA for the 3 years, and while you get the money into your Roth IRA and let it start growing there, especially in this down market, you might be able to move more money over. I want to point out that there's been some huge increases in premiums in life insurance by 13 of the major companies. So if you have experienced that and are thinking about cashing in your life insurance, I want you to know that you might want to consider selling it on the secondary market through a life settlement company. Those companies are out there. You want to talk to your insurance professional, your insurance advisor, because they can access the better life settlement companies. So I've come to the end. That's a wrap. We're going to take questions now. It's right at an hour, which is what we planned for my presentation. We welcome you to ask questions through the Q&A of this. If you have a personal question that you don't really want to ask there, or it gets too complicated, I invite you to call my office and set up a 15-minute conversation that I'm doing for free. I generally do those between 9 and 10 o'clock in the morning, just sort of a warning. But my staff will make an appointment for a 15-minute call with me, which I am happy to do with you. So, now we're done. And I want you to all know that I thank you so much for listening, and I want you to take care of yourselves and each other. So Lara is one of the associates in my office. She is also my daughter. So she has been an attorney now for about 14 years and has joined our firm in the last year. So Lara, do we have some questions?
We do. We have a few questions here. A bunch of them actually are about the Secure Act, drilling down a bit more. Maybe they missed part of what you said. So here's a question we had about the Secure Act and deferring taxes on 2020 distributions. Can you defer part of the taxes for up to 3 years and then pay some each year over the next 3 years? Or is it an all or nothing deal? It's all taxes in 2020 or all in 2023?
So I'm sort of confused because the 3-year deferral of the taxes on a retirement account is the CARES Act, not the Secure Act. So do think in terms of that. I believe that, and I don't handle income taxes filing myself. I know a lot about income taxes, but I can't hold myself out as an income tax expert. So you want to talk to your CPA about this for sure. But my understanding is that you don't have to defer all of it for the 3 years, that you'll be able to pay it. You can defer it for up to 3 years. So that to me means that you'll be able to pay it before that if you choose to.
Another question is rollover from traditional 403B to Roth 403B tax deferred for 3 years too?
Any withdrawal from under the CARES Act, any withdrawal from your retirement accounts, the 401ks, the 403Bs can be deferred up to 3 years. So if you take it out and there's no restrictions on what you do with those funds. So if you're rolling them into a Roth, you ought to be able to still defer the taxes. Again, this is an in-depth income tax question and is best addressed by your CPA to make sure that you can. But now you're aware of it, you should go and find out for sure.
Okay, so now there are two actually about the Secure Act. Those two were about the CARES Act. This one is, if my spouse is more than 10 years younger, is the rollover IRA the better option since there's no stretch option?
So spouses are not required to be within 10 years. That was other people within that are not your spouse that are within 10 years also can do that stretch. So the spouse can be of any age to do the stretch, but usually from a financial planning perspective, and this is not always, but usually a rollover to the spouse's own IRA is a better tax planning strategy. Again, you need to talk to your CPA about your specific situation.
Okay, and then we have a question early on. What effect do disposition documents have on estate taxes?
So estate taxes are none of the documents are going to change your estate taxes. You can do tax planning. A lot of the irrevocable trusts are created for tax planning in advance. There's many kinds of avenues to try to reduce estate taxes, but the documents that I talked about, the basic living trust, the beneficiary designations, none of those are going to have an effect on your estate taxes. They are going to avoid probate, which is the other demon, I guess most people would think of it, in estate administration. So avoiding probate is the goal of many of those kinds of documents. But tax planning can be done. It is whether you need to do it or not, and how to do it depends on your situation and your wealth. The estate tax exclusion is now $11.58 million per person. So a lot of people do not have estate taxes and a taxable estate. If you do have assets that are above, let's say about 6 million and up to the 12 million, there is a possibility that the estate tax exclusion amount will come back down sometime in the next 5 years. And if that happens, then you might lose that ability to exclude those assets from taxes. So you should talk to an estate planning attorney or an elder law attorney about your options and the best way to avoid taxes.
Okay.
And I just used a word of avoid. Avoid means you done it legally. Evade means that you did it illegally. So we don't evade taxes, we avoid taxes.
Okay. Another question that we've seen a couple times here. Many of the documents you've mentioned are available online through LegalZoom or Rocket Lawyer, those types of software programs. What are your thoughts on using those programs? And if we do use those programs, are they legally binding if we use them without an attorney review?
So are they legally binding? If they are created correctly, that means they're executed correctly, and there are requirements for execution of these documents. If they're executed correctly, and that you know what you're doing, you know what the document is, you know what it does, so that there isn't a mistake and there isn't fraud or undue influence in you creating those. Yes, those documents are going to be valid. But are they going to do the job that you intended? And as I've tried to express, there's so many complexities in estate planning, and those documents are usually very, very, very simplistic, and they may use terms that you don't understand. So I don't ever recommend that someone use those. But maybe that's my bias because I'm an attorney and That's what you might think, well, that's what any attorney is going to say. But I don't recommend them generally.
Okay, another question. What if I'm concerned for a parent or family member who may be resistant to planning but is declining with age?
Yeah, this is a hard one. If someone is declining and they don't have documents, it might be that you have a number of family members who try to talk to that person. Some people are very, very hard-headed. They just are not going to do it. They think if they do it, they're going to die. And that's just it's not logical, but it's what they feel. So they may not do it. You might encourage them through a discussion of the cost that it's going to be and the burden. Most seniors don't want to be a burden on their family. By not doing planning, that might create, that will probably create a much bigger burden than if they go ahead and do planning now. Planning is sort of a gift. One of the other things that some seniors won't do it because they don't want to spend the money to do it. Sometimes I've recommended that the younger generation, you never know what to give that older generation for holidays or birthdays or anniversaries. Buy them, prepay the legal expenses for an attorney for them to set up their estate plan. They might then figure, okay, well, the money is spent. They might as well go and do it. So those are some ideas, but I sympathize with you.
All right, so I think we have time for one more question, and then I'm going to turn it back to Josh. So Janis, one last question here. It's kind of a two-part question about using your IRA to donate to a charity like West Valley Community Services. How do I get more information on doing that? And will a withdrawal from my IRA to make this type of donation be non-taxable or deductible?
So there's two ways you can do this. The best way to do it is to utilize, and I can't think of the right terminology for it, but you can allocate your required minimum or your distribution to the charity up to $100,000 a year. The best people to talk to about that, again, might be your CPA or your financial advisor. If this is something that you have a financial advisor to consult with, and they oftentimes have the documents. If you don't have a financial advisor, say you have an account at Fidelity, connect with Fidelity and find out, how do you go about this? And you allocate it so that it doesn't come to you. If it does come to you, if you take the money out, you can always, of course, give it to the charity, but then you're going to have to report it on your taxes, and then you're going to get a deduction. You can avoid that whole having to report and the deduction piece of it by having it go directly from your retirement account to the charity. And I wish I could tell you exactly how to do that, but that again is more of an income tax question.
All right, thank you so much. I'm going to turn it back to Josh to wrap things up.
Thank you so much, Laura. And thank you, Janis, for that incredible presentation. I have learned so much today I didn't know, and hopefully all of our attendees have learned a lot as well. We will be sending out this presentation to you probably next week, so please feel free to review it again when you have a moment. And we're also going to be sending out a survey after today's program. So please give us your feedback. We want to know what you thought about today. It will help us for future presentations. Again, thank you so much, Janis, for joining us today and for sharing all that you know. It's incredible, and we're just so grateful for you taking the time with us today.
My pleasure.
Awesome. So Janis referenced our Legacy Society. We do have a Legacy Society here. It's people who have indicated that they are intending to include us as part of their estate plan. I've included some testimonials from folks up on the screen right now who are intending to make a gift in support of the Legacy Society. It's easy to join. You can find out more information online, or you can also reach out to our Director of Development, Kohinoor Chakravarty, at development@wvcommunityservices.org. She can answer any questions you have about the Legacy Society or about supporting West Valley Community Services as part of your estate plan. We can also give you more information about our programs and services and what we're seeing here as relates to COVID-19. I also want to again direct you to the law offices of Janis Carney. She really graciously offered to provide some free 15-minute consultation if you have further questions. Her email information is on the screen as well. Please make sure to jot that down if you want to follow up. You can also find her online at the website on the screen. That brings us to the end of our time today with all of you. Thank you again for making the time to spend with us today, and we look forward to hearing from you and talking to you soon. Wishing you and your family all the best. Please be well and take care of yourselves, and have a wonderful day.